so wrong, and what are we going to do to improve it? And that's one of my overriding points, that all the pressure comes from outside, from good politicians who want to make change to stop it happening again, from good lawyers, from good journalists, from good academics, obviously from the families themselves, from people themselves who have to campaign. So obviously I wanted to start with the 97, and they're always in our minds, they're always in our hearts when we talk about this subject. We always have to remember that this is all about the families, this is all about the 97, and this is all about survivors and people who were really, really terribly affected by this. So this is a Liverpool Football Club memorial to them, because it's got the face wall on it, so you can see everybody in one go. So we used to have a face wall, but then our designers decided that, and I hope none of them, that didn't mean to criticise them in that way, but for the 35th anniversary they decided that this was better and more easier for readers to be able to actually, you can click into. So this is John Paul Gilhooly. He was only 10 years old. He was the youngest person to die, to be unlawfully killed at Hillsborough on the 15th of April 1989. At the second inquest, the families were finally given their voice. They were finally given respect by the legal system in that arena. And it started with personal statements that were made about the people who died by their families. And so what I did was just to report on the personal statements, to summarise them a little bit, to try and take some of the love that was shown for them by their families and some detail about their lives. And you can click through and you can read about them, and you can read these heart-wrenching but also loving testimonies that their families made. Now, Patrick Thompson was the first, his wife Kathleen was the first person to make a personal statement at the inquest. So here we were at this moment that had been worked for 25 years of campaigning, and finally they'd got this terrible first inquest quashed, which I'll explain to you about the process. Don't worry if I've jumped ahead. I just want to tell you a bit about the 97 first. And there we were in this, it was a business, it was actually an office block that had been, and it was used as the courtroom, huge room. All the families were there finally getting their voice and their moment and hoping, turning up for justice. All the lawyers, packed room, and Kathleen made this statement, and she and Patrick had 5 children. The oldest, you'll see in the detail, was 5. There were 5, 4, 2 I think, and 2 baby twins. And if you see what Kathleen said, here, she said, it was an address to the jury. She said, "Please listen to the evidence and let my children know that their dad was not a hooligan, but a hard-working family man who just happened to love football." And that was the very start of the inquest. And we were just sitting there saying, he had 5 children and he went to the match. In 2021, Andrew Devine, who had suffered brain damage. So this is another aspect of the Hillsborough disaster, is that when we talk about 97 people were killed and 400 were injured, it was only like really explained, I only realised, and it was made clear to me at the inquest actually, like really listening to the detail. When we talk about injuries, yes, it was a crush. There were a lot of people who broke arms, broke ribs, had awful, what we think of as physical injuries. But because it was a crush, and at this point I'll say obviously, like, yes, it is very distressing, as Ethna said. I know that there is going to be some distressing detail as we go along, so you know, it's inevitable, and absolute understanding for anybody, especially anybody who's directly affected, for whom it is too distressing. So, but I'm just keeping to what I'm talking about is just to help you understand it, to make the points that I think are really important to make. And so part of what we could talk about as the injuries, because it was a crush, people obviously couldn't breathe, so they lost oxygen. So a lot of the injuries were actually brain damage. And Andrew had catastrophic brain damage and was cared for by his family, and by obviously had the best care that he could have until 2021. So what's that? 32 years. 32 years after he went to a football match. And then he finally passed away in 2021, and the coroner ruled that he died due to the crush at Hillsborough, and he was the 97th person who'd been unlawfully killed at Hillsborough, and the 96 became 97. So that is why we now have 97. I was just going to say a little bit about my own background really quickly. So yes, that's the football business that Andy read, and he's got his own story about how he came to read it. I think it involves a broken nose, but I can't quite remember the full details. I think you were laid up, weren't you, in hospital, and someone bought it for you. And in that, yes, I wrote about the commercialisation of football after the disaster. So, and I had a chapter, and Jimmy McGovern had produced a drama documentary on ITV that exposed and dramatised the injustice that the Hillsborough families had suffered. So that had already happened. So, and that opened my eyes. And so I wanted to write about Hillsborough partly because it's part of the history of football, of how football changed. But I obviously wanted to understood that there was a huge injustice that had happened, and wanted to write about that. So I wanted to include it and incorporate it. And I ended up having with a chapter in that book called The Rebuilding Process. And what that did was it contrasted the rebuilding of the football grounds that had happened as a result of government following the Taylor report, forcing the grounds to become safe and become all-seater. And the clubs went to the government and said, that's fine, but we're really poor and we haven't got any money. And they were given grants, which I added up to £200 million, to help them build all-seater stadiums. And at the same time, the Hillsborough families, who'd suffered in the disaster that led to this report, that led to the clubs being given public money to rebuild their grounds, had no money, no public funding for legal representation, and were lost in this nightmare legal system, suffering injustice. And so that chapter contrasted the families with football's fortunes after the disaster. And the first family who I went to interview were Phil and Hilda Hammond, and it was their 14-year-old son Philip who'd been killed at Hillsborough. And Phil was the vice chair of the Hillsborough Family Support Group at the time. A wonderful man, wonderful people, wonderful couple. I went round there, and we always remember it, and ended up staying there for 3 hours, sitting around the kitchen, talking about all these issues. And Phil really opened my eyes to it. And so I took so much from that into the book, writing about the Hillsborough injustice for the first time, which was published in 1997. And ever after that, I always, as I made my own way in journalism and tried to have other opportunities, I always wanted to take every possible opportunity to raise the Hillsborough injustice and expose the issues that Andy was talking about that I finally managed to do, and try to expose them and confront the authorities with this massive injustice that had happened. And yes, Phil Hammond just passed away last month. A great person, a loving father, and a magnificent campaigner. And always, to be honest, he's always been in my heart, always, ever since first meeting him then. A great loss and a tragedy that their happy family life with their lovely 2 sons turned into this nightmare ordeal, of a tragedy, a disaster, losing their loved one, and then this nightmare of having to fight the legal system. Now, I've learned over the years that just to try to explain what happened, it'll save me convoluted explanations if I just actually play you this video that we made in 2016, because, you know, we've put a lot of time and effort into creating it, and I think it shows you what happened better than I could sit here and explain it. And a particular part of it that I'm going to develop as we go through is the match commander, the police officer in charge of the football match, Chief Superintendent David Duckenfield, and the lie that he told as the disaster was happening. If you concentrate on that and understand that, I'm going to be I'm going to be talking further about that later on. So I'm going to play the video. I'm not going to play the whole 11 minutes because we've run out of time, but I'm going to play you enough so that we can understand what actually happened that day. On the 15th of April 1989, 54,000 people attended the FA Cup semi-final between Liverpool and Nottingham Forest, which was held at Sheffield Wednesday's football ground, Hillsborough. 96 men, women and children who went there to support Liverpool died in a lethal crush on the Leppings Lane terrace. 400 more were taken to hospital with injuries. After a 26-year fight for justice by the victims' families, the South Yorkshire police officer in charge, Chief Superintendent David Duckenfield, admitted at the new inquest into the disaster that his serious failings caused the deaths and injuries. But at the time, even as people were dying in the central pens of the terrace, Duckenfield lied and said that Liverpool supporters had gained unauthorised entry via an exit gate. In fact, he had ordered it to be opened. The police had to correct that lie, but it nevertheless started a story which the South Yorkshire Police told to the media and official legal procedures which followed, that the people who had suffered themselves were drunken hooligans who were to blame for the disaster. The new inquests, ordered after the first inquest, was finally quashed in December 2012, started in Warrington in March 2014, and have become by far the longest case heard by a jury in British legal history. A huge volume of evidence has been heard about the disaster and about the decisions South Yorkshire Police made, leading to the appointment 19 days before the semi-final of Chief Superintendent David Duckenfield, who had never commanded a match at Hillsborough before. Wright's removal of Chief Superintendent Mole followed the disciplining of 8 other officers for an excessive prank they played on a probationary constable in October 1988. The official reason for Mole's move to Barnsley was that it was career development, that he was an expert at football policing and had commanded the semi-finals at Hillsborough in 1987 and 1988, which was also between Liverpool and Nottingham Forest. If the move was for career development, the inquests heard no explanation about why it was so soon before the semi-final, where the senior officer was responsible for the safety of 54,000 people. Duckenfield, a known disciplinarian, had policed in Sheffield city centre, but had not even been on duty at Hillsborough for 10 years when Peter Wright promoted him to replace Mole and take command of the match. Mole had had a detailed knowledge of Hillsborough, including the Leppings Lane turnstiles, which was allocated as the end for Liverpool supporters. The approach was a narrow bottleneck, along which 10,100 people had to be funnelled in through just 7 turnstiles. In major admissions at the new inquests, Duckenfield confessed that he failed to do basic preparation for the semi-final. He did not even visit the ground before signing off the police's operational plan, and he failed to read relevant safety documents. He admitted he knew very little of the ground's safety history, that there had been crushes at the 1988 and 1981 semi-finals, and he was unaware of the basic layout of the Leppings Lane end. That included a large tunnel facing the turnstiles, which led people down into the central pens of the terrace. Duckenfield did not even know that the police were responsible for monitoring the numbers of people in each pen, and he admitted that his focus before the match was solely on dealing with misbehaviour. He did not consider the need to protect people from overcrowding or crushing. Nor did he know that the police had a tactic, named after a superintendent, John Freeman, of closing the tunnel when the central pens were full and directing arriving supporters to the side pens.
There's gaps, you know, in parts of the ground. Well, you look at the Liverpool end to the right of the goal. There's hardly anybody on those steps.
Having failed to prepare, Duckenfield admitted when he gave evidence 26 years later. I'm going to try not to stop too much because it'll take too much time up, but this was one element of it which Pete and his colleagues did brilliantly at the inquest. The story that people arrived late and that's what caused that's somehow what caused the inrush, the crush. If you look at the timestamp, this is BBC film from outside. So that's more than 20 minutes before the kick-off at 3 p.m. and that is the chaos outside. So the idea that this mental image that they got in everyone's minds that people had come late and just rushed the gate. If you came late, you'd be how far away? You wouldn't get anywhere near the people who came late. And part of what you all did at the inquest was just play the actual film of what happened to rebut all the lies. He failed profoundly at the match itself. Mole would be taken by a driver all over Sheffield in the hours before a match to check on arrivals and trouble spots. Then he would patrol around the ground leading up to the 3 p.m. kick-off, talking to his officers, particularly at known difficult areas including Leppings Lane. Duckenfield has never been able to account for what he did in more than 2 hours between briefing officers and arriving in the control box at 2 p.m. Once he was in the small control room which looked right over the Leppings Lane terrace, he stayed rooted in it. Superintendent Roger Marshall, who was put in charge outside, was new to the role. He didn't stagger people's approach to the Leppings Lane turnstiles using police horses or cordons to direct them into queues. The thousands of people arriving to support Liverpool walked into the bottleneck, and the 7 turnstiles were not adequate to allow them through quickly. Marshall told the new inquest it was one of his most profound regrets that he did not ask for the 3 p.m. kick-off to be delayed, which would have relieved the pressure of people anxious to be in for the start. He conceded that he did not give any orders to alleviate the developing crisis outside, and as more people continued to arrive, the congestion compacted into a dangerous crush. Marshall admitted that the police had no control of the area, and he began to fear that somebody could die outside. He then radioed the control box to ask for the large exit gate, Gate C, to be... So just one point to make, which I'm hoping that I'll be able to develop a bit later, is that this is the moment when the order is given to open the gate, okay? But 4 minutes before that, the gate was briefly opened by a police officer. I think actually, and correct me if I'm wrong, I think it was actually to eject somebody. So they opened that exit gate briefly to eject somebody, and that's going to be relevant later on if I've got time. Opened to allow a large group of people in and alleviate the crush outside. At 2:52 p.m, Duckenfield, who was asked 3 times, finally ordered Gate C to be opened, and 2,000 people were directed by police officers to go through at once. They included 30 who went into the central pens, were carried by the pressure of the crowd to the front within minutes, and were among the 96 people who died. Duckenfield admitted that when he ordered the gate to be opened, he gave no thought to whether people would go once they'd been guided in. He didn't foresee that they would go down the tunnel facing them. He didn't order any police officers inside to direct the incoming people away from the central pens, round to the sides where there was still room. In detailed medical evidence, the inquest heard that the victims suffered compression asphyxia, causing their hearts to stop because the crush in the central pens was so fierce they could not expand their chests to breathe. Survivors of the crush gave graphic evidence about being unable to help people who were dying around them, some people about passing out themselves, and about the terror of being trapped. The police and ambulance service were slow and disorganised in their response response to the emergency, the inquest heard, although some individual officers made great efforts to help. Among the Liverpool fans were doctors, nurses, off-duty police officers and firemen, and many people with no medical training at all, who in the chaos tried to save people.
I know that the decision was taken to open the gate. I know it was a considered decision on the basis of what could be seen.
Under repeated questioning, Duckenfield admitted in his evidence that when he failed to foresee where people would go when he opened the gate, he froze, and he acknowledged that his failure to close the tunnel was the direct cause of the deaths of the 96 people at Hillsborough. At the time, though, he did not admit that, and neither did South Yorkshire Police. At 3:15 p.m, even as people were dying, Duckenfield told Graham Kelly, the Secretary of the Football Association, that Liverpool fans had gained unauthorised entry through the exit gate. So the reason why I use the phrase unauthorised entry is because that is what he admitted to at the inquest. Duckenfield, I think that was the form of words that he used, but essentially all the evidence from the FA officials was that Duckenfield had told them that Liverpool fans had forced the gate.
There are two versions of what went wrong. The first is that a door or doors was forced down. The second is that a door or doors was or were opened by someone in authority.
Peter Wright had to correct the lie later that evening, but Wright himself personally oversaw his forces campaign which followed to deny any failures and to allege that the disaster was caused by many Liverpool supporters having been drunk and arriving at the match late and without tickets. And I'm going to stop it there. And that's explained and showed you better than I could have done. Is this too loud or is it fine? What happened? And now I'm going to explain to you some of the legal processes that followed. So this is a timeline that I did, which goes through all the justice and injustice and landmarks that happened. In 1989, given a disaster on that scale, there was a public inquiry by Lord Justice Taylor, the Taylor Inquiry. I wanted to show you, I could only find it on the Wayback Machine online. I bought a copy. This is the interim report, is the report that is about the cause of the disaster itself. Then there was a final report, which was the one that sadly is more famous because it's about football, and that was about safety at football grounds and that recommended all-seater stadiums and a new safety regime. And I can tell you for a fact that most people have heard of the second one, that recommended all-seater stadiums, and most people haven't heard that, don't even know that that Taylor ruled on the causes of the disaster. And this is a huge and hugely important part of the story, and a hugely important part of the question of how did the legal system deal with what happened? How did it go about trying to establish the truth and justice? So this is a public inquiry by one judge sitting on his own. Yes, all the relevant people are represented, but part of the unfairness and inequality of the system that the second part of Hillsborough Law is aimed at addressing is that the South Yorkshire Police, the ambulance service, the council, whose safety regime failed, and Hillsborough was an unsafe ground, as Andy said, with no valid safety certificate, and other public authorities had publicly funded legal teams to represent their case at the inquiry. The families whose loved ones had gone there and been killed had no funding, there was no legal aid for representation at the inquest. At the inquiry or at the inquest. And I was always told, and I wrote in the football business, that of the families, 42 of them were able to pay £3,000 each, which is whatever that adds up to. I I think I've written £142,000, but 3 times 42, not much money for all the processes that followed. And they were always outnumbered, they were always outstaffed, and they never had the legal representation that was needed to see them through. But Lord Justice Taylor actually saw through the South Yorkshire Police case. And in a famous phrase, he said that the prime cause of the disaster was the failure to close the tunnel when the gate was opened, the failure to close off the tunnel and direct people to the sides, and that was a blunder of the first magnitude by David Duckenfield, and that's the famous phrase. And he also has a passage, which if we had time I was going to take you to, where he criticises the South Yorkshire Police for the false case that they made, trying to make out that the supporters were drunk and misbehaving and had arrived late, which they maintained all those stories, even though they had to admit that the story about the gate was a lie. All the things that supported it, which was that they came late and they didn't have tickets, so they needed to force the gate down. Even though you lost the actual reason why they would do that, which is you lost that they forced a gate down. No, they didn't. They still kept all the other elements of the story. They were drunk, they didn't have tickets, they came late. So Lord Justice Taylor this report is 4 months later. Sorry, that's the final one. The interim report was 4 months later. Within 4 months, in August 1989, he said the prime cause of the disaster was mismanagement of the crowd by the police, that the case against the supporters was essentially false, and that the police should never have made it. And he criticised the senior ranks of the South Yorkshire Police for making that case, blaming the victims, instead of taking responsibility themselves in very strong terms. But it then went to the first inquest, which is... now, what I was going to do to show you this is take you to the Hillsborough Independent Panel report. So that seems like I'm jumping forward, but the reason for this is because if anybody wants to study everything that happened up to 2012, this report, which I bought my hard copy. I just bought these copies because I just wanted to sort of show people that just the importance of these documents that do establish truth and that do play a role in justice. And in Liverpool that night, after Bishop James, who was the chair of the panel, produced the report and explained it and released it and gave out copies, I sort of had the privilege of reporting on it for The Guardian and then basically going to the pub with Andy Burnham and whoever else and loads of survivors and family members and people who'd struggled and fought for years. And there were people walking around Liverpool like this was a holy document, a holy book. And that's what it means. This is what these documents, when justice is done, this is what they mean to people. So the panel report goes through the chronology of what happened. So the first inquest, when people ever say, when people used to say, what are they fighting for? What are the Hillsborough families fighting for? Essentially, there was a specific miscarriage of justice, which was the first inquest. So an inquest is there to say and to establish the truth. It is a truth-seeking endeavour. It's not like a criminal trial where it's just a guilty or not guilty verdict. And it's to say, how did this person die, when, where, and the families. It was held in Sheffield, and Phil and Hilda Hammond used to tell me about going every day from Liverpool to Sheffield. They had to get childcare, obviously, for all the other members of the family who had to be left all day. They felt terrible about that. Their whole, that was a big trauma for them, a big guilt that the other siblings suffered as a result of this. And this is the amount of time that it all sucked up. But at the inquest, despite what Lord Justice Taylor had said, these stories about drunkenness and ticketlessness and lateness misbehaviour by Liverpool fans were rerun again by the South Yorkshire Police. And also a huge emphasis on drinking. And the other really big plank of the inquest that was so resented by the families was that he cut off taking any evidence at 3:15 p.m. on the day of the disaster. And the evidence that supported that was that everyone was dead at that point. People died very, very quickly, all from the same crush. And therefore, there was no need to take any evidence after 3:15 p.m. And the families campaigned against that because, first of all, they didn't believe it. They didn't believe that people just died really quickly and didn't have a chance, and that they hadn't had a chance to be saved. There was even evidence from people who had seen signs of life amongst some of the, as it then was, 95. And also they felt that just took away a proper inquiry into the chaotic response by the police and the ambulance service. And it was a huge bone of trauma, a huge ordeal, this 3:15 p.m. cut-off, as well as the false narrative that was presented by the police. But it was held. That is how those were the rulings. And in March 1991, the verdict came from the jury of accidental death, and that was the inquest verdict that led the families campaigned against all those years, and that they had to fight for an ordeal for 20 years until 2012. This is the piece that Andy was referring to that I wrote in 2009, that he read, and that, as he said, had a moment of clarity for him, which obviously is you know, it's fantastic that it prompted some action, and the work that he did and the efforts that people made after that to try to overturn this miscarriage of justice. I featured in that piece Anne Williams. I hope that a lot of you will be familiar with Anne Williams. She was the subject of the ITV drama, I think it was January last year, and her fight for justice for a 15-year-old son, Kevin. Now, Anne was one of those people, and she had actual witnesses who had told her that they'd seen signs of life in Kevin after 3:15. And that was a really very big part of Anne's campaign. It was specifically against the 3:15 p.m. cut-off because she had evidence that Kevin was alive after that time. And so in this piece that I did in 2009, I went to see Anne and interviewed her and reported some of this detail. Now this I wanted to show you. So she had this letter from a doctor, Ian West, a consultant forensic pathologist at Guy's Hospital. And he said that he had given her an expert opinion that Kevin that Kevin was alive after 3:15, and that the 3:15 p.m. cut-off wasn't medically sustainable. And Anne had this letter from Ian West, and she showed me the letter when I went round that day. And she'd basically been carrying it around for anyone who would listen, for a lawyer, Elkin, who's here. Great to see Elkin here. I think, Pete, you represented Anne, trying to get justice for this issue and for the other issues that Anne had, without success for many years. And the first point at which the families appealed was in 1993. And this is a lesser known part of the story, but is so important when you're looking at the legal system, because too often an appeal doesn't look at a blatant injustice in front of their eyes, the judges, and say, our system's gone wrong. How on earth was this inquest allowed to run? We've even got the Taylor report there as a document that shows that a Lord Justice has found in this way, and then this coroner in Sheffield has held an inquest, that's been conducted in this way and come to essentially, as the families felt, as basically rebutted or disregarded the Taylor report. But the 1993 appeal was rejected by it was a high court, it's called a judicial review, but in effect it was an appeal, was rejected by the judges, and Anne was one of the families. I think it was 8 representative families, but it may have been reduced to 6, but they were representative of all the families, and the 315 cut-off was one of the grounds of appeal, that medically that was just wrong, plus all the other issues about alcohol being brought into the first inquest, and that the police, it was a false case, and that there hadn't been sufficient inquiry at the inquest. They were turned down in 1993, and that led them to having to fight for 19 more years until Andy made his intervention, his political intervention, called for all the documents to be released. I remember the process. I remember him telling me, this is what I'm going to call for. And I don't think it had all been thought through right at the beginning, and then everyone realised, well, we can't just get them to reduce the documents and have some massive dump on the internet that everyone can look at. We're going to have to set up an expert process somehow where experts can look at all the documents and produce a report. And the panel was set up by agreement. So they did have Professor Phil Scraton on there, who was a great academic with incomparable knowledge of Hillsborough, who'd done really, really substantial work on the disaster up to that point, and the families insisted that Phil Scraton be on the panel. But there was also a police expert, and it was agreed to by the South Yorkshire Police and by all parties. And I think, Bishop James, you've always felt that it's a very good model, that sometimes if you can keep things out of a courtroom and out of the adversarial battle and have an expert panel that will look in the round collectively, collegiately together and come to an agreement, and I think you had unanimity about the report, and come to an agreement about what really happened, then you'll save trauma, the live theatre, the battle in front of people's eyes, and you'll be able to come to conclusions. And so the panel was set up, and you spent 3 years looking at all the documents and then producing the report. And in preparation for this lecture, I've honestly learnt some detail about 1993 and what happened then that has really opened my eyes. So the panel report essentially found, again, that terrible mismanagement by the police had caused the disaster, that there was no credible evidence of misbehaviour by the supporters in any way, and you also had really, really shocking new details about how the police had mounted the false case, the infamous briefings to the Sun newspaper of like the worst lies and smears that had been made, throughout this awful process. And David Cameron, who was Prime Minister at the time, made an apology in the House of Commons for what he called the double injustice, so the disaster on the day and what he called the injustice of the legal system causing the families to have to fight for the truth for so long. And then finally, in December 2012, really quickly after the panel report, finally, the Lord Chief Justice of England and Wales sat in the High Court in London, and this is 2012, 23 years after the disaster, 21 years after the inquest verdict of accidental death, and quashed it in about an hour. And this isn't even a long judgment, it's really short. And it was a huge day of vindication, obviously, for the families. Like, it was incredible that the inquest was finally quashed. And I was there on the day, and in fact, that's the first time I met Pete Weatherby, because you were representing the families at the quashing of the inquest. And obviously, it was a huge day of vindication, but I remember even on the day. So if you look here, what he's doing is saying, yes, the 3 p.m. cut-off was invalid, it was unsustainable, it should never have, the medical evidence is now that they should never have had a 3:15 cut-off. They're saying that alcohol was given too much prominence at the inquest. Dominic Grieve was the Attorney General, and he actually, on behalf of the government, called for the inquest to be quashed. There was no opposition to it. And I remember Dominic Grieve saying that one of the grounds for quashing the inquest was that the victims had been denigrated, and that victims shouldn't be denigrated at an inquest. And I thought, this is what these families have been saying for 20 years, and they've hit a brick wall for 20 years. They've spent their lives, their family life, they've lost so much. There's people have been ill, people have died. And now and it was really jolly. The atmosphere was really jolly, like, we're quashing this, you know, I mean, obviously, and there's a line here that says, where he says about the Taylor report, and he says that, I'm just going to find it for you. He says that should have been that. So he's talking about the Taylor report, and he says, Taylor found, you know, what he found, it was a blunder of the first magnitude, and that they should never have said that, and it was a failure of police control. And he says, that should have been that. Unfortunately, the culpability of the police was not acknowledged, and a campaign was mounted to undermine confidence in Lord Justice Taylor's conclusions. So here we have him saying, the Taylor report in August 1989, that should have been that. But that's what the families and everyone in Liverpool, everyone supporting them, had been saying since August 1989. Now, the grounds for quashing the inquest were principally the 3:15 cut-off. And the rationale that they used was the Hillsborough Independent Panel. So a doctor who was on the Hillsborough Independent Panel called Bill Kirkup, he had reviewed the medical evidence, and he had found that, yes, it wasn't medically sustainable to say that they were all dead by 3:15. So the court said they're essentially taking that as new evidence, and that was the grounds for quashing the inquest. They say in here that the 1993 appeal had a letter from Ian West, but it hadn't been enough to agree for the judges to agree that the inquest should be quashed. Now, I've honestly only kind of seen all this properly in preparing for this lecture. And obviously I was very, very interested in that because Anne Williams showed me that letter when I went to see her in 2009. So I followed up on that, right. And it seems like this judgment, this historic judgment by the Lord Chief Justice that quashed the Hillsborough inquest after 20 years, that's a mistake, that's not right. And that in 1993, they didn't just have a letter from Ian West, which is what it says in this judgment. And Ian West, who was a leading forensic pathologist, had actually done a report for the Hillsborough Independent, for the 1993 appeal. And because the panel is such a brilliant resource, and it's all in the National Archives now, they had a reference to it. In your report, you've got a reference to this. And that is Ian West's report for the 1993 judicial review. And he says in here, on behalf of the 6 families, 4, including Kevin Williams, and I didn't even realise that Philip Hammond was one of the 8 people that had been asked to do a report on. And you'll have to correct me if I'm wrong on the detail here, because we can all read it afterwards. But from reading it, it was that 4 of them, the medical evidence was that they were not dead by 3:15. And this had gone to the 1993. And basically, in your report in 2012, it says in the report, and I would find the reference if we had time, we agree with Ian West. And then the judges in 2012 had said, we agree with the independent panel. So therefore, there is a direct line to the quashing of the inquest in 2012 that it's based on Ian West's original opinion. Because you've said, we agree with that opinion. But in 1993, that opinion wasn't considered valid enough to quash the inquest. And that consigned these families to 19 years of an ordeal of banging their heads against a brick wall, of being told you've got nowhere else to go. You've had your appeal, in effect, the judicial review, you've had it turned down. But as it turns out, it was finally quashed by the judges in 2012 on that jolly morning, on exactly the same grounds that the judges turned down in 1993. Right. I could honestly take all day to talk about just this particular detail and this particular aspect of it, but the overall point that I'm just making today is, where does that question get answered now? Where do we go now and say, how did you do that? How did they lose 19 years? And why is there a mistake in the judgment that says it was just a letter, so it wasn't enough? So that's what happened in 1993, and it's really, really important, because if they don't recognise an injustice in front of their faces at the appeal point, then people have got nowhere to go for 20 years or so. And it's really important to understand that the way that it was overturned in the end was a political intervention, not a legal. There was no legal vehicle. Elkin and Pete Weatherby took Anne Williams' case to the European Court and didn't succeed there. There was no legal vehicle. It was a political intervention that changed that produced a new analysis, this report, that had no legal force whatsoever. We all reported on it as a massive story. Then there's a Prime Minister giving an apology in the Commons, and suddenly the same evidence that had been put in 1993 suddenly becomes grounds for quashing an inquest. So then there was a new inquest. Now, Anne Williams died in 2013. She turned up at the quashing of the inquest in December 2012 in a wheelchair. So she lived, and this is my piece when Anne died. So she lived long enough to see the inquest quashed, but she never lived long enough to see the true verdict for Kevin. And she spent a whole life after 1989, like so many of the people, just on this, just fighting injustice. And I hope I've shown you, with going into that detail, that's injustice. There's not a rational explanation. I don't think there is. So at the new inquest, Anne didn't live to see the new inquest start in 2014. This is really important. I just wanted to say that at the inquest, David Duckenfield gave evidence for, I think it was 7 days. He made all the admissions about his own failings that were on our film that we just showed, and he admitted that he lied when Graham Kelly came into the control box and said that the gate had been forced, or, the form of words that he used was unauthorised access, and he did actually apologise. And it turned out, because I was going to write that day, I was there that day, and I was going to write admits for the first time, and that's what my editor said, is this the first time? And it turned out, actually, no, he did sort of apologise. He always really admitted, even at the Taylor inquiry, that he'd lied, and he did sort of apologise there, and to be fair to him. And so that's why we didn't say admits for the first time. So the inquest, and I don't have time to talk about how magnificent the lawyers were, how magnificent Mark George was. It was a horrendous, horrendous process, because the lawyers for the police and for the police officers reran the stories of drunkenness and ticketness and lateness, even though the Lord Chief Justice had said, please don't do that again. And so you had to fight you had the battle of your lives, you had to fight every single detail, but you did fight every detail and you didn't miss anything. And so finally, there was the verdict that the 96, as it was then, had been unlawfully killed. Now, this is really, really important. So this is the inquest verdict, or the determinations, as I call it. And the whole Hillsborough inquest is in the National Archives. This is the verdict, the overall verdict. And question 6 was, are you satisfied that those who died in the disaster were unlawfully killed? Answer, yes. And what I want to explain to you is the unlawful killing verdict is that there's legal directions here that say the unlawful killing verdict is based on a finding that David Duckenfield was culpable of gross negligence. But what's really important is in that bit of transcript that I was going to show you there, is that they missed a word out which was in the legal directions in court, which is manslaughter. So here it says, to answer yes to question 6, you would have to be sure that David Duckenfield, the match commander, was responsible for the manslaughter by gross negligence of those 96 people. So when they said yes to the unlawful killing verdict, they were saying this was manslaughter, this was gross negligence manslaughter. That is the inquest verdict. So then the other, question 7, which was horrendously tense for the survivors, for the families, for everyone, they actually put supporter behaviour to the jury. Like, did supporters' behaviour contribute to the dangerous situation outside the Leppings Lane turnstiles? So after all this fight for justice, it could have ended up with the fans getting blamed. And it was, again, we could be here all day just talking about that and what happened, but the jury had seen everything. That video, it wasn't just Pete and Anna and Mark George and all the great lawyers' arguments. You literally played the video for a lot of the inquests. It was just seeing what actually happened. And the jury said no. So no behaviour by Liverpool supporters contributed to this disaster. That is a legal finding. There are death certificates. After an inquest, you have a death certificate. The death certificate says the 97 were unlawfully killed, and part of the verdict, part of that finding is that there was no misbehaviour by Liverpool supporters. This is the individual questionnaire. So each of the 96, as they were then, before Andrew Devine passed away, there were individual determinations of how they died and when they died, right? And Kevin Williams, sorry, he's got a middle name, hasn't he? So Kevin Williams is on here. Obviously, all of the 96 are in here. They're all equally important, but I'm just showing you how Anne Williams's case from all those years was vindicated. Time of death, from 1505 to 1545. So Anne had carried this letter around from Ian West for all those years. She wasn't alive to see this, and she'd lost in court after court. They'd been rejected and had nowhere to go. And then finally, this was on the 26th of April 2016, finally you could see that she was right all along and that the evidence that she'd been carrying around was vindicated. So this was a great day for the Hillsborough families. That's just a big piece that I wrote after the inquest that you can read if you have time. This is the family's high point, in a way, outside the inquest building. But unfortunately, it was the high point because they went from having a team of lawyers who represented them to, well, what happens next? Well, if there's been an unlawful killing verdict, if there's been such an absolute scandal about the fact that this case that was put by the police has been completely discredited and disbelieved by an inquest jury, well then there has to be some form of accountability. and the accountability that was tried were prosecutions of David Duckenfield, now, and of 3 other officers charged with perverting the course of justice for the changing of the statements that Andy was talking about. So one very quick aspect that I want to mention is when there's going to be a jury sitting to hear a court process, just because there's going to be 12 people there, right, who are pulled in from the general public, they have to be kept in complete ignorance of everything that's happened. They have to be a blank slate, and only what's said in the court is what they should hear and what they should consider. So therefore, all media reporting about that issue is really, really strictly controlled. And it's not really reporting restrictions, but it's a contempt of court to report anything that isn't just what is happening in the process. And so even the inquest, which started in 2014, was going to be a jury, and it was kind of like, don't report the panel findings too much before that process. Then they reported in 2016 this huge moment of vindication, and there was massive reporting, and you'll all remember it was a huge, huge, huge story, and that's when the message got across to the public. But then they charged Duckenfield and they charged these other officers in 2017. From then, we couldn't even report. In my reporting, I couldn't even say there was an unlawful killing verdict. You couldn't even report like the legal fact of what happened, of history, because then they would be prejudiced that, oh, well, this has already been decided that it was unlawful killing. So we have to keep the whole country in ignorance. We can't actually keep telling everyone what the outcome has been of this battle. And, you know, there are a lot of Liverpool supporters who believe that that's why it's all crept back in football grounds, talking about that it was the fans, you know, this toxic chanting. Because if you add it all up to the final verdicts of 2021, it was nearly 10 years that you couldn't really report it all properly. Okay, and I just wanted to make that point, that I think that's another issue that needs looking at. What, to keep 12 people? And why shouldn't they know what the legal findings have been? Like, aren't we supposed to be trusting a jury that they can put things out of their mind and they can really concentrate on the evidence? Anyway, we then sat through these prosecutions. I know that I've gone on for too long, so I'm not going to be able to talk about all the things that I plan to talk about these prosecutions. But essentially, what happened was David Duckenfield was found not guilty. The 97 were unlawfully killed due to gross negligence manslaughter to a criminal level of proof. That is what the jury decided in Warrington. He was then prosecuted for gross negligence manslaughter, but he was found not guilty. So the legal, and this was in 2019. So the legal outcome after 30 years of processes in courts, that is the legal contradiction that the families have been left with. And then and I've written a piece with quite a few issues that came out of that trial, which I don't have time to talk to you about now. The 3 officers, it was 2 police officers, and 1 solicitor who acted for the South Yorkshire Police, who were charged with perverting the course of justice for the process of amending statements. They were acquitted, but it was because the trial was stopped, because the charge was perverting the course of public justice by amending the statements to go to the Taylor inquiry. But what was found by the judge was that the Taylor inquiry wasn't a course of public justice. It was a different kind of inquiry. It wasn't a judicial inquiry that's part of the justice system. So therefore, if they did change whatever they did with the statements, it couldn't be a crime of perverting the course of public justice, right? And in one of the, within the judge's actual judgment, there was a point made that said, and this here is where I've said, some of the arguments were glaringly unattractive for the law. And this is in the judge's judgment. He noted of solicitors' duties, and I think it's the same for barristers, that they must not positively mislead a court. So a lawyer mustn't positively mislead. He mustn't mislead a court. But if they realise a court is acting on a false basis, they still have no duty to correct the court. So lawyers can be in court. The court can be they can know that a court is literally arriving at a decision on a false basis. But my understanding of this is, but if it's in the favour of their client, whichever side it is, even though they know it's false, they don't have a duty to correct it. So therefore, from what I can see logically, that means they know that there could be a false outcome of this case. The actual outcome could be false. And presumably that means somebody could go to prison who shouldn't be wrongfully convicted, or on the other side, victims could be left with the perpetrator unaccountable. And the lawyers know, but they don't have a duty to correct. And I do have a question there, which is, where's the duty of candour for the lawyers? Like, how have we got a legal system with no duty of candour? Why have we got appeal judges who can't take a view and say, yeah, this just does not look right, we need to overturn it? And my bigger questions, this was a big long read that I did about this whole process, how they were failed by the justice system after 32 years, because that final case was 2021. I think what I want to say is, this was a piece I did on the 35th anniversary, and I interviewed families, and it was a bit more personal because there wasn't a big justice case. They've got nowhere to go now. So I interviewed them more about how's it been, what's the impact been on you, and this is what we've ended up with. After 35 years, the pain of injustice remains raw as ever. And Louise Brooks, whose brother Andrew was one of the 97 who died, said that the Duckinfield trial made her ill. She got ill after the Duckinfield prosecution. And it's not necessarily that he was acquitted. It's not necessarily the outcome. It's what the trial was like. Going in there again and seeing all this false case being presented again and just tried on a new jury. But we just had a 2-year process at the inquest, and we've got certificates that say there was no behaviour of Liverpool fans at Conn. How is this being rerunning? Well, let's just try it again in front of a new jury and see if they believe it this time. And that's literally what happened. The same evidence that was demolished by Pete and his colleagues was just rerun, and this time it got a bit, it did a bit better, and so the big point that I want to make at the end of it is that this is what our legal system did following a disaster which was horrendous and horrific and caused the deaths of 97 people, but actually had quite a clear cause that was identified by a judge within 4 months. How did we get 32 years and end up with so many failed processes, an appeal that was just dismissed, and now I've shown you that basically when the inquest was quashed, it was essentially for the same reasons as 19 years earlier. So you could have been spared all that time. And that you end up with nobody held to account for 97 people unlawfully killed and a case made by a huge police force that was totally disbelieved by a jury. And that it shouldn't just be me standing here and saying, how did that happen? Like, literally, that is a question that needs answering. But I don't see that happening. I don't see that there is sort of like a legal system institution that is taking seriously the failings that it perpetrated on something so serious and so huge. So I don't feel like there's accountability from the legal system. And I think that so many of the elements of it should be questioned. And we might come out of it and say, no, actually, they are the best they can be, but they need improving in some ways, and sometimes they can go wrong. That honestly might be the outcome. But I think the adversarial system, where two sides are battling it out against each other, and unless you've got the best of the best and money to fund it, you could just lose just because you haven't got the firepower against the person on the other side. And there's no quality control by the court itself. That's just the arena. That's the battle. That's the live theatre. what's happened and reporting on them has led me to question the jury system and whether it works as well as it could work. The fact that juries don't have to provide written reasons, why not? And we all know that it helps with your decision making, it helps with your thought process if you have to commit reasons in writing, if you have to put something in writing. The appeals process, so often it rubber stamps the first decision and then it turns out 20 years later, oh, actually that was a miscarriage of justice. But for 20 years they've been saying, well, the Court of Appeals looked at it, so it can't be. So I believe that these issues about the legal system, they're not the most exciting. When I'm trying to get them in the newspaper, it's obviously much, much more compelling to talk about the case, the actual case, rather than the general issues. But that's partly why the general issues don't get debated, they don't get discussed, they're not part of public discussion. But the legal system as it is has produced this outcome for these wonderful people whose loved ones just went to a football match. And therefore, what I want to do, and also encourage anyone who's working in this field to just work on it, to develop thinking on it, is, you know, does our system need massively improving? Does it need modernising? And that all these questions should be asked, and that much more work should be done on whether we need improvements and what improvements we need. So I've probably gone on twice as long as I should have done, 3 times as long as I should have done. So I'm really sorry, but I hope that was, you know, interesting for you, and thank you very much for listening.
David, no one wanted to stop you because I think it's fair to say you have got the most encyclopedic knowledge of what happened at Hillsborough. And I'm sure Bishop James and the others from the panel will forgive me from saying that. But also your analysis of not only the disaster itself, but what's happened subsequently is absolutely second to none. So we all wanted to hear every aspect and every detail of what you had to say. So thank you so much. Can we just give another round of applause for David?
Thank you.
It took me right back to sitting at Phil and Hilda's kitchen table when I represented them at the inquests, and you're right. And the kindness and the humanity of people, even in grief and bereavement, is outstanding, isn't it? And there's sort of 4 things from what you said that I wanted to kind of draw out, and maybe we'll pick up in the discussion later. Candour, why people don't say that they got it wrong and things went wrong. Second question you pose is why did you get it wrong? Why don't we talk about what went wrong and why? What do the documents say? What does the original source material say? You showed us some of those documents there where the truth was for so many years. And then the fourth point, what do the families say? What do the people who were there say? What's their account? What's Anne Williams' recollection of what happened? What are the survivors' recollection of what happened? Those 4 themes, I think, still play out in disasters and tragedies to this day. I was sitting with 25 families this morning with the Secretary of State for Health, and there's exactly those 4 themes which came up in 2025. So everything you've said has got incredible resonance with justice campaigns that go on to this day. So thank you very much indeed. I'm going to ask Pete to respond.
Yeah.
So you can
sit down
off the hot seat for a moment. So you've heard a lot already about Pete Weatherby, who is another founder member of Garden Court North Chambers, and you've heard that he and Mark led the team who represented 22 of the bereaved families at the historic Hillsborough inquests. And Pete was instrumental in drafting what we're colloquially referring to as the Hillsborough Law, but I'm sure Pete can give you the full title and citation. Pete is very humble, but he won't mind me telling you that he's appeared in some of the most significant criminal trials, public inquiries and inquests over the last 20 years, including the Grenfell Inquiry, the Undercover Policing Inquiry. He's currently leading teams representing over 7,000 bereaved families in, I think, 8 modules of the COVID inquiry at last best count, and has appeared in every court from St Pancras Coroner's Court to the European Court of Human Rights and everything in between. So Pete, would you be kind enough to give us your response? Thank you.
I don't recall being called humble before. I'm also going to be very brief because I know that you've not come to listen to me drone on. I was going to speak about Mark for a little while, but most of what I was going to say has been said. I worked with Mark for over 30 years. That makes me very old. He was a great friend as well as a colleague and a mentor. A couple of things about Mark that haven't been said really, that if he was here, he would be really interested because he was a big fan of David. He would open his Guardian and go straight to the David Conn column. He would therefore be first through the door, last out of it at the end of the night. But he would be sat at the back and he would be cringing a bit because he would wonder why it was the Mark George Memorial event, because he was a very humble person. Those of you who knew him, that'll be no surprise to you. Those of you who didn't know him, if he was here, you would know him by the end of the night. Because although he would talk to me, he would talk to Anna, he'd talk to David, he'd talk to the Bishop, Andy Burnham, we would find him in the buffet afterwards talking to you. And one of his massive strengths was that he used to go off for weekends to teach trainee lawyers. And he used to go off for weekends and train people in the anti-death penalty campaign, Amicus. And he did a tremendous amount of work at that level that was unseen. And he didn't want to be seen to do that. So big shout out and big respect to Mark. On to David, but on a journey. The justice that we talked about in terms of Hillsborough in particular comes back to the families. And I know some of you are here or watching online. I know Margaret Aspinall and Sue Roberts and Charlotte Hennessy and Steve Kelly and no doubt many others are watching. The families are what achieved the justice that was achieved for Hillsborough. And the families were at the heart of it, and they did it. We've heard about Andy Burnham's role. Andy played a huge part in it. We've heard about the role of the Bishop. The Bishop played a huge part of it. David was the link between all of them, between the families, the story, the facts, the analysis, Andy Burnham, the Bishop, and many others. So he made it work. Just one further word on the families. We've heard talk about Anne Williams. Anne was my first Hillsborough client. And a good story that I often tell about Anne was that shortly before her very untimely death, I was talking to her, and she was recounting that along the journey, along the 27 years journey, she'd been sat opposite a senior police officer who was giving her a book of excuses about why this had happened and the police hadn't really done this and hadn't done that. And she said it was all just a wah, wah, wah. She'd heard it all before and she was trouble even maintaining a concentration. And she said to me, I just thought to myself, you'll give in before I do. And that's the story of Hillsborough. That was her story, but it's the story of every one of the 97 families. Justice was only achieved to a certain level in Hillsborough, as David's recounted, but the justice that was achieved, it's really clear it was only achieved when the families were in a driving seat, when the families were empowered. So the whole journey through the first defective inquest, all of the different judicial reviews, trips to Strasbourg, all the rest of it, all of those that failed, the Stuart Smith travesty, all of those that were failed, the families weren't empowered. They didn't have the backup, the funding for the technicians, the lawyers, if you like, to help them. Only when Andy Burnham picked up their struggle and the Bishop picked up their struggle with David's assistance, were the families actually involved. They became involved in the Hillsborough Independent Panel, led by the Bishop, chaired by the Bishop, and then they were given public funding for lawyers for the fresh inquest. They had full disclosure, and suddenly the lights turned on. They were empowered, they could challenge the false narrative, and they started to get some justice. But there's a sting in the tail, and that's where David finished in his lecture, that after that, after the families have been empowered, and it returns to a process where the families are sidelined, the criminal processes, that those then failed. There were the two prosecutions that followed, they failed to bring anyone to account. I'm not going to go into the weeds of this, I'm not going to say anything about the verdicts, but it is an interesting and important point to note that the families, when the families are empowered, there was some justice. When the families weren't empowered, there wasn't. And that's a lesson for the future. David's mentioned juries. I disagree a little bit with David on this subject. Juries are good. The Hillsborough jury, David showed you their reasoned conclusions at the end of the 2 years of evidence, a fantastic underlining of the importance of juries, because juries can actually grapple with properly complex issues and come up with reasoned conclusions. They can do it. It's a ringing endorsement of juries. I've personally been across the world. I've been to Turkey, Bahrain, Kuwait, and sat in observed controversial trials. I've done a jury trial in Mauritius. I can tell you, where there aren't juries, the standard of justice is a lot worse, a lot worse. So we should really value our juries. The problem with the process here is that once the victims, the families, were dropped out of the process, they had no representation. So when the families were watching, as members of the public, the processes that were going on, they had all sorts of issues that they wanted to raise in those processes, and they couldn't do it. They had no locus, no legal standing to do it. So they couldn't then say, well, hang on a minute, why is this being said? Why are they being allowed to get away with that? What's this about? And I think that one of the lessons of Hillsborough is in very controversial cases involving prosecutions of state officials, for example, families should be represented, not before the jury, but they should be publicly represented so that they can make representations about the process. And I think if that happens, then in the future there'll be a higher standard of justice. Finally, the second point, and this is moving on to Hillsborough Law. The cover-up in Hillsborough was, as David has outlined, it was industrial. Drunk, late, ticketless fans. Not true times 3, as proven at the second inquest. Promulgated by the Chief Constable that you saw on the video, Peter Wright, and his team. He set up 2 distinct teams to run an industrial cover-up of that eye-watering nature, which persisted for decades. For the fresh inquests, the former senior officers were separately represented from the police, and they still ran that narrative. They were still able, because of the legal process, to run that narrative. That was wrong. That led to a hugely lengthy process, very stressful for the families, where all sorts of nonsense was put before the jury about the Heysel disaster and football hooliganism going back into the 1960s and 1970s. So why is that allowed to happen? The answer is that there should be a duty of candour. If there had been a duty of candour in law at that point, South Yorkshire Police would have been required to tell the truth about what had happened. By the fresh inquest, they'd publicly admitted that senior police officers had lied. They'd publicly admitted that it was the police that had caused the disaster. But they didn't say that to the jury, and their former senior officers were able to say the contrary. If there'd been a duty of candour, they couldn't have done that. This is not just a Hillsborough issue. This is an issue which goes across just about all inquiries, all controversial disasters and outrages. I'll just run through a few of them. Andy referenced the blood contamination issue. As a minister, the Minister for Health, civil servants gave him the wrong information. He described it as a lie, which he then innocently put out to the public. That was a lack of candour. In the post office scandal, we all know now that the post office knew about their defective systems, yet they carried on pretending that they weren't defective, and people were prosecuted, and people took their own lives and went to prison. The Manchester Arena outrage. We had MI5 on oath saying that some of the intelligence that they had, they didn't realise was to do with the bomber or the bombing. When the evidence was heard by the chair of those MI5 officers who'd received that, that wasn't true. The former Chief Constable of the Greater Manchester Police, to the inquiry that Andy set up, the Kerslake inquiry, into the police response to the Arena outrage. He sent a letter to Lord Kerslake, which wasn't true. He admitted subsequently that it was a grave error. We heard yesterday MI5 and the BBC, untrue, to 3 different courts asserting facts which were not true. In 2022-23, I was on the international panel that looked into the UEFA near disaster at the Champions League final of 2022. It had eerie similarity to Hillsborough, where French ministers, the French police, the French football authorities said that there were thousands of football supporters who turned up without tickets, late. Eerily similar. It was eerily similar also because it wasn't true. So the Hillsborough Law writes this. If it's passed, and it's a big if at the moment, if it's passed properly, what it will do is it will impose a duty of candour, a legal duty to tell the truth. It will do so with a legal toolbox to enforce it, to require compliance with it. What that means is that the Chief Constable or a senior officer will have to sign off a narrative at the start of the investigation about what their institution's case or what their narrative of the facts is. And if that is put forward falsely, willfully and intentionally falsely, then that will be a criminal offence. So would the former Chief Constable have put this false account to Kerslake? And by the way, he maintains it was innocently false. I'm not arguing about that. But would he have done that without checking that it was right? Would MI5 have put forward this account of the intelligence they had about the Manchester bombing without checking whether it was right if there was this duty of candour? Well, of course not. The Hillsborough Law has the potential to massively rebalance the system. It has the potential not just to force public officials and those acting in terms of public health and safety to tell the truth proactively, but it also rebalances the system because it establishes a level playing field for victims of disasters and outrages and things like this, so that people are actually in the room and have rights and have lawyers. We're at a critical point. Some of us in this room, Ian, for example, Ian Byrne, MP, Andy Burnham, myself, we've been consulting with, helping, assisting, whatever the word is, ministers in terms of getting it right. We've been saying, don't rewrite Hillsborough Law, pass it. We'll see in the next few weeks whether they do. If they do, it'll make a massive difference. If they don't, it'll be a massive disappointment. Thank you very much.
We run out of time.
I think we're now going to assemble ourselves as a panel, and
We run out
Claire
of
is
time,
going
really.
to do the honours with
We run out of
the
time,
Rovers
really.
mic.
Keep going, yeah.
Yeah, I think we've got time for about 2 questions. So,
Do you want a drink? Do you want some water on it?
I think we've got time for about 2 questions, and please wait for the microphone to get to you to ask them. So, who wants to be one of the lucky two who asks a question? The first person to
I
ask
think
a
the
question.
bishop's gone, hasn't he?
There you go. There's somebody there.
Can I ask about, David says, who's going to be called to account? And there are these technical measures, new laws, duty of candour and so on. People still lie under duty of telling the truth, they lie in court and so on and so forth. Do we have to think about more generally, who are the judiciary? The people who oversee these processes? Because the justice system is partly institutionalised, it's partly structured by the law, but it's also the people who administer the law. Where do these people come from? And do they come from the same place often? Do the people who have ultimate responsibility for appeal courts and so on, do we need to think about maybe opening up those levels of justice to different types of people? In other words, is it a broader socio-cultural issue that we're looking at?
Well, Pete is going to know, and Anna are going to know more of the inside information about that, but I think you're making a really valid point. But I also think, apart from it not presenting as an institution that you can hold to account, that you can give that will actually provide information, right? I think that it's really opaque. So, like, it's really hard to answer your question because we don't really know. And also, it's very, very disturbing about the appeals. Okay, like, I didn't have a time, so now you've given me a bit of a chance to say one little detail that I wanted to mention to you, right? Which is when they turned down the 1993, in that judicial review, when they refused the family's application to quash the inquest, they didn't just say, you haven't got enough evidence to quash the inquest, the medical evidence was fine, the 315 cut-off was fine, the alcohol, it's all, they didn't just say, it's fine, we don't have legal grounds to overturn it. They said, the coroner did his summing up impeccably. And you must see that all the time. They go too far. It's never just, you haven't got not never, sorry. They don't just say quite often, oh, you haven't got legal ground. They say, it was simply impeccable how they handled it. And then you find it's one of the greatest injustices that we've ever had in the country. And it affected so many people. And I do have a concern, right? What's the separation between the appeal judges and the judge? Aren't they part of the same profession, really? Are we going to an independent appeal process here where they're prepared to do the hard thing and say, sorry, that's really, you've got that wrong? Or do they think, well, he's going to be sitting with me in a few years? And do people have words with each other? Do they have a word with him and say, was that all right, your process? Yeah, I'm sure it was. But there's no answer to that. I don't know. Who are the people? Yes, you can get the backgrounds of the people, but how does it work? How does this institute... And when you hear about it, a lot of what the institutions are like seem really archaic, really old-fashioned. Yeah. Like, sometimes if we're talking about these issues, it gets a bit of a laugh when I start talking about wigs and gowns, right? But actually, I feel really that that's a really serious element. So when we were in the inquest, that's a less formal process, and you were not wearing wigs and gowns and you were in suits. And I think it actually does make a difference, and it feels more modern and more human, right, for the people. But in the prosecutions, everyone's in wigs and gowns, the judge is in robes, he's sitting up on a platform like that. There's the royal coat of arms or whatever it is. It's the Crown prosecuting. And at the Preston Crown Court, the press box was a bit raised up. There were like three steps to go up into it. So you're sort of looking down a bit at these horrible, grubby, filthy wigs. And you're watching this process going on, which is basically going against the inquest, which was the longest case ever heard in British history, which you could say that was British justice working, that came to determinations that are written down, that are accepted as the truth, and that provided some. And now I'm sitting in this court with and it made me feel like the formality of it, and the pomp and circumstance, and the language, and the dress, and the architecture is framing it as some awesome process that can't be questioned, right? That imposes awe and deference on all of us. But it's so important to see beyond that, and to see that there are many areas in which it's not fit for purpose, like you've had to bring in a Hillsborough Law because there are areas of the law that aren't fit for purpose, and that we need to be asking questions, and we need the Hillsborough family. I was sitting there thinking, not just here they are without any lawyers, which is a really, really important point. Of course they needed lawyers there. But also it was like, it's your system. Why are you there on the fringes of this thing? It's the people's system. So a long-winded answer for your question again, but the key to your question, I think, is this institution and the people in it, is it serving the people and doing what it should be doing? And I think that the message that I'd like to give is we need to ask these questions and we need to demand answers.
Do you want to say anything more to that?
Very quickly, the answer to your question is yes. I think there's a case, as happens in some other countries, to have judges who don't come from the legal system. So you have a separate track where judges are trained. You could then make it much more diverse, both in socio-economic terms and across the piece.
I think, just to add to that, if I may, I think the diversity point is really important, because one thing that struck me both about Hillsborough and Manchester is you had very capable but quite establishment experienced judges leading those investigations, and I think they were both shocked, and sort of their expectations of the state was shifted dramatically when they heard the evidence. And I think that only happens when you have an investigative process and where that kind of evidence comes out. So I think as access to justice improves, the more cases can be brought that can kind of educate judges and lawyers as to what's possible, and that sort of people's justice that David's talking about. But also when you have a bar and judiciary that's reflective of all experiences and all diversity as well. You know, Leslie Thomas's speech at the beginning of Grenfell, where are all the black lawyers in the Grenfell Inquiry? And you know, the representation, that connection with the actual people of our country.
Okay, have we got time for one more question? Oh, sorry. We are going to be outside, so we can ask questions after. So we'll have time for one more, just there. Sorry, we can ask it later.
Hi, I wanted to ask, how do you balance the desire for individual criminal liability with the need for candour? Because obviously somebody's less likely to be candid if they know it's going to lead to individual criminal conviction.
Take that one.
Yeah, I'll do that quite quickly. We've built that into the proposal. The proposal for a duty of candour is not incompatible with safeguards in criminal law. The privilege against self-incrimination should be untouched. The duty of candour should be generally on the institution. If it relates to the individual, they should delegate the duty to somebody else. And that's all covered in the proposal.
I'm actually sort of meant more generally, like thinking about your point, David, about the fact that two juries came to different conclusions. Like, how do you deal with that? Because, Yeah, in the first one, you might people are less likely to tell the truth if you know that is going to end up in a conviction for gross negligence manslaughter, rather than there being a separate process when they then have to go through the criminal process.
That's a very good question. I don't really know the answer. Right, and this might seem like another kind of left field way of thinking, but you know, I feel like I or we in the media, journalists, students, academics, you can stand outside of the system and try and see it from a broader perspective. And I'm speaking slightly off the top of my head in response to your question, but this is something that I have thought about, and that is it too punitive? Is the system too punitive? Is there too much about criminal liability with horrible punishments at the end, like going to prison? And that if we didn't have such a punitive system with such extreme punishment, might people have more of a get out to admit mistakes, to admit the truth, if the risk isn't so high? And I sometimes feel that, not just in the court system, but kind of generally, if the consequences, everyone can make mistakes. I'm not saying that that's very different from gross negligence, don't get me wrong. I'm just talking in general that I think your question is, you need people to be honest without thinking, but if I am, my whole life could be totally ruined. And I know Pete's got technical solutions for that, but I'm answering more in principle that as part of questioning all of this, I do question the level of punishment and the level of criminality that's applied to consequences.
Do you not think, though, that sort of when gross failings tend to occur after there's been a culmination of either failures or behaviours that kind of lead to a serious failure, like at Hillsborough and like other examples, but if there was an incentivisation for people, whether that's police officers, healthcare workers, maternity staff, to actually report concerns in a safe place, it would then remove the chance and opportunity for those gross failures to kind of manifest, and they build up. Whereas they don't need to necessarily remove the criminal provisions, but we need to encourage, make it safe for whistleblowers and make it safe for staff and for patients and for ordinary individuals to report things as part of a kind of a suite of cultural reforms to encourage kind of better safety and better candour. I think if we only focus on the end kind of punitive part, we risk not looking at where most sort of concerns get raised at the grassroots levels, as individuals and individual, whether that's officers or whether that's intelligence agents or whether that's doctors and nurses. So I think you can see it as part of a range of solutions, if that makes sense.
Okay, I think Pete wants the final say.
One final point on this. At Hillsborough, there was a young female police officer who we saw on the video, in fact, at the fences at the Leppings Lane end. And she gave evidence 27 years later at the inquests on oath, and she was right at the end of her career at that point. And there was a weight fell off her when she gave evidence on oath, because what she said is she wrote a truthful statement about what she had seen at that fence. And a senior male police officer had stood over her and ripped up her statement and told her to rewrite a statement that wasn't correct. You have a duty of candour. She can stand up to that senior officer. The senior officer probably won't be stupid enough to try it. And by the way, I think it should be very punitive in that circumstance if it actually goes.
Yeah, I'm not saying there shouldn't be any punishment for terrible acts. Of course I'm not saying that. But I was just trying to put the thought in that and I fully agree with you, Anna, about making it easier in general in the process for whistleblowing and for candour and for honesty, and without so much consequence and fear that, you know, it's all going to go terribly wrong if I am honest about this. But I do also question how much punishment and how much prison there is.
Sure, absolutely.
Okay, and I think we have completely run out of time. I've got a few thank yous to do. So bear with me a second. And a short poem to read. I haven't, this is completely out of my comfort zone. I don't think I've written a poem since I was doing GCSE English, let alone read one out loud. So this is sort of my tribute to Mark. But before that, I'd just like to thank Creative Manchester for all the support and some of the funding that came from law and from social sciences, but also to Anna, to David, and to Pete as well. And also, here's my poem to finish the evening called, and we debated this earlier on, I've debated earlier on with Suzanne what to call this, but I've called my poem The Lefty Lawyer. We gather here and online to honour one who knew the case, not just of law, but of the fight for truth, for justice, for what is right. A voice unwavering, bold yet wise, a fearless gaze, sharp and clear-eyed. He stood for those the world ignored, for justice lost, for lives implored. Through hallowed courts, through whispered doubt, he shone a light, he spoke aloud. With every word, with every plea, he carved a path so others see. For those condemned by fate's cruel hand, for wrongful convictions and broken stands, he challenged not for wealth or name, but for the fairness of the game. His legacy in ink and breath endures beyond the reach of death. For truth is not a fleeting call, it stands, it fights, it lifts us all. And so we gather, minds ablaze, particularly after everything we've heard, to carry forward Mark's just fight, not just in words, but in our deeds, to serve, to challenge, and to plant new seeds. A life well lived, a purpose true. Mark George KC, we honour you. Drinks and reception. So we can continue our conversations outside. So and thank you everyone for coming.
Well done.